I know that there's supposed to be some snow coming, so I figure maybe we can start a little more quickly, and depending on the questions and things that we talk about, we can get out of here a little more quickly. As always, sure. As always, I appreciate everybody coming out tonight. And as I typically do, I'll give everybody an update of where we are right now. To the extent that you've been following the website and the progress of the case, then it should be of no surprise to you that we have been, I guess I'll say, struggling to get documents from the various parties that we've sought documents from, whether it be the former St. Joe's entity or the diocese or Prospect or the Attorney General's office. We've had struggles. The first depositions, the first subpoenas requesting those documents were issued sometime late October, early November. It was not until, I'd say, sometime in the first to second week of December that we started to receive the documents that we had asked for, which was approximately 3 weeks late at that point. And the court thankfully intervened and directed everybody to provide the documents and set some pretty strict deadlines for those parties to adhere to. While I am happy to say that we have now received almost everything that we had asked for, the difficulty that the delay has caused is, instead of getting documents over a period of weeks on a what I call a rolling basis, we in essence got huge dumps of documents. So while we could have been reviewing documents through November and December, we really had to wait till the middle part of December to start reviewing documents, with the bulk of them coming, I'd say, within the past 2 to 3 weeks. So we have now been faced with boxes upon boxes, hundreds of thousands of documents that, quite frankly, we have to touch and look at every single one of them, because you don't want to miss something that could be important to our situation here. So as a result, it's backed everything up from what we had hoped where we would be today. That's not dire, but it is unfortunate, and it is frustrating. I'm sure it's been frustrating for you, because it's been frustrating for me. I'm trying to figure out what happened, and I've only been involved for the past few months. Many of you worked there for 40-plus years and are still trying to figure out what's going on with the pension. But as I said, we're reviewing the documents. I have spoken to Special Counsel Attorney Wistow in his office. Because of the delay in getting those documents, he is not comfortable in making a recommendation to me just yet as to who we will pursue against to try to recover monies. But we do expect to be there, although now it looks like we may not be in a position to do that until March, maybe April. Because, like I said, we've been backed up by about 45 days. We had hoped to have that information now, but that's now pushing us into maybe mid-March to the beginning of April. I understand that. The court understands that. I have spoken with the judge on a number of occasions. I speak with him quite often about the circumstances. So everybody is aware of the timelines and the impact that those timelines have. I can also tell you that I have mentioned to groups in the past that we were looking at whether or not there could be some recovery through PBGC. While I can't give you anything of substantial information regarding that, I can tell you that we have begun formal discussions with the PBGC, which, to those of you who either don't remember or haven't been here before, that's the Pension Benefit Guaranty Corporation, which is a federal agency that is put in place to ensure ERISA plans. And although this plan had been designated by St. Joe's historically as a church plan, there is a potential to argue that it should not have been. and we have begun the discussions with the PBGC with that regard. Those discussions are in their very, very initial stages. We have provided several hundred pages of documents, actually several thousand pages of documents to the PBGC so that they could review and start to make their assessment as to what they believe the circumstances are. But again, those discussions are in their early stages. There was a meeting, I think it's been 3 weeks now, down in Washington, D.C. So we met with the PBGC down in Washington, D.C. about 3 weeks ago to start those discussions, and we've been in constant communication with them since. So those are what I kind of call the parallel path, because the PBGC issue is separate and apart from the potential claims that we could bring against other parties, and so we're pursuing both of them at the same time, and the document issue is the review with regard to the claims, and then our meeting with the PBGC and starting those discussions to explore what options are there or the other side. With all of that now being discussed, and again, I'd be happy to take any questions from anybody once I'm done talking, that puts us into where are we now with regard to this proceeding, what are our next steps. As I said, I had hoped to have a clearer picture of claims and even the PBGC piece by now. I don't. So we are walking into, there's a hearing potential, let me correct that, there is a hearing scheduled, or that will be scheduled. I don't know if it's been docketed yet. Has it been? Has not been. We've asked the court to put it on the last week of February, and that is the hearing that you all know of. That is the one where there would be a recommendation on whether or not there's an adjustment to benefits. Although I cannot tell you yet what I'm going to do, and the reason for that is not because I'm being evasive, it's because it's a very difficult task that I'm hit with. I've got a lot of things that I'm trying to figure out. I'm working with the advisory committee, which has met on a weekly basis and has been helpful, but I haven't finished, quite frankly, the report that I'm going to be filing with the court. I plan to have that finished in about a week and a half, and as I write it, it evolves. And so I don't even know, as I sit here right now, what I'm going to be recommending to the court. I can tell you that as I stand here now, although don't anybody hold me to this, people who are going to be watching this later either, as of right now, my leaning is to ask the court to hold off a cut for another short period of time. I had originally asked the court to put it off until January, February, so I could get a better handle on the circumstances with regard to claims. And as I just stated, I haven't gotten the documents, or at least I've gotten them, but I haven't had a chance now to review them with Max as much as we possibly could so that we can have a better handle. So the problem that I asked the court to extend that time frame for is still present. I didn't expect it to be, but it is. In addition, the PBGC side of it is that I don't want to do anything to the plan in February that could disrupt my efforts with the PBGC as well. So I've got those two things that I'm working with that are pushing me towards asking the court to put off that cut until after the last week of February. 30, 60, 90 days, whatever. I haven't come to a decision yet on how much time, and quite frankly, it won't be up to me. It's up to the gentleman in the black robe. And so I'll make a recommendation, and he will decide whether or not that recommendation is prudent, and he'll decide whether or not the recommendation on time is prudent. So that's where we stand right now. There are also, you may see in the next coming week to 10 days, there are a couple of other things that I plan on filing with the court, not related to the cuts, that you'll see. I'm not yet there yet, so I don't want to reveal yet what I'm doing on that piece of it, but it has nothing to do with cuts, but it would result in, if the court granted the relief I'm asking for, it would result in me getting access to at least several $1 million rather quickly. That's a drop in the bucket of what we need, but every bit helps. And like I said, I plan on filing that hopefully within the next week to 10 days, and with possibly a hearing prior to that last week in February. So that would jump in front of the February hearing. Other than that, from a status standpoint, the court proceedings, the motions to compel on the subpoenas have really taken the front seat in terms of the activities of what I've had to do and what special counsel has had to do. There's been the meetings with the advisory committee, which have been, I think that those meetings have been very, very helpful. And they have been very constructive in terms of trying to figure out exactly what we're wrestling with. But that's where we stand as of right now. If there's something I didn't mention that people have questions about, I'm happy to answer them, but I'll open the floor now to anybody who has a question, either about anything I just talked about or generally. And as I always say, if you ask a question, I will answer it as completely and honestly as I can. That may include me saying I can't answer that question right now, either because I don't have the information or I can't do it in a public forum because of the legal aspects of things. But I will do my best to give you as complete and clear an answer as I can. If anybody has any questions, could you go up to the mic so that everybody can hear? It's only a step away. Thank you.
It's my understanding that there is $80 million sitting in the Charter Care Foundation.
I heard that was reported somewhere. The number is...
I don't remember where I read it, but I believe... I don't remember where I read it. If that's true...
That's not true. Let me put that.
It's not true?
The statement was that there's $80 million sitting in the Charter Care Foundation. That's the number of charitable assets that were transferred in 2014 from both Roger Williams and St. Joe's was approximately, and I looked at it today, was approximately $8.4 million, not 80.
Okay,
that's a big difference.
Big difference. Okay. Seeing that Charter Care no longer exists, is it possible that whatever funds are in the foundation could be transferred over to the pension plan?
Well, I can, excuse me. It wasn't the question that threw me off. That was just my throat. Charter Care still does exist in some form, and the Charter Care Foundation, correct.
Under Prospect.
And the Charter Care Foundation still exists as well. What I can tell you is that is absolutely one of the things that the special counsel and the receiver are looking at. That money was... to give everybody kind of a brief background of what that is, when the hospital, which was a not-for-profit hospital, was operating, people or entities would donate money, which they sometimes specifically directed what its use should be, and sometimes just gave it generally. To the extent that that money was donated and had a general purpose, then the hospital, at the time of the sale, was able to identify some of those funds and put it into the general fund of the hospital, which is used to wind down efforts and things like that. If there was a donation made by a person or an entity that was specific and had a very specific purpose, then the law says that to the extent possible, the purpose has to be fulfilled either exactly as intended or as close to the donor's intent was. So, for example, if there was a donation and the donation was that this money goes to the nursing school and is to only be used for the nursing school, and the nursing school no longer exists, then the hospital could look at, or in this case, the transferring entities could look and say, okay, is there education that we could put it towards that's still connected to the hospital? If not, then what happens is it goes to another organization The Rhode Island Foundation is one, Charter Care Foundation is another, that can help to put that money and direct it towards as close to the purpose as it was originally intended. Because this is a case where I don't really trust anything that happened, not because I think anything was done wrong, but I just want a new set of eyes to take a look at it. The special counsel and I are looking at all of the funds that did not get transferred into the general fund, but rather went to either the Rhode Island Foundation or the Charter Care Foundation to see. It was done via court order, so a court did review it initially, but it was done based on a recommendation of the Attorney General and the selling entities. And so I'm reviewing those transactions and those charitable assets to see if it's possible to call some or all of those back under some theory. So that's a long answer, I guess, to tell you that I'm looking at it. If we can, what's termed claw back those monies and argue that they had more of a general purpose rather than a specific purpose, or that maybe they should not have gone to that purpose under the circumstances in which these hospitals were left in 2014, then we're going to try to do that. Again, though, those monies were transferred in accordance with a petition that was filed jointly by the applicants to the transaction and the Attorney General and was approved by the court. So I just want to temper expectations on my ability to claw that back, but I'm looking at it.
Okay. Thank you.
You're welcome.
No, just a quick question. A lot of people have been talking about that pension will not get touched until after April.
Say that. I'm sorry. Say that last
part.
part.
About the pension not being touched until April.
What do you mean by that?
Like, if we will still get our full pension.
Oh, yeah. Yes.
And is that definite?
Well, I think the discussion on that, the answer to that generally is likely yes. The reason why is even if I were to go into court that last week of February and ask the court to adjust benefits in some way, and let's say the court agreed to that, that adjustment would not happen or the order wouldn't enter by March 1st, which is when the next round of benefit payments go out. So it would take at least the month of March for the processing and the implementation of that cut to be put in place. So even if February resulted in some adjustment, it would not impact benefit payments until April 1st.
Oh, mine is a similar question. It was just that, are they going to deduct 40% off the pensions when they come to it, or is that just a random number that we began with?
That's just a random. The 40% number was a number that was suggested by St. Joe's in their petition. Because of that, it has been grabbed hold of. But I can tell you that the discussions with the advisory committee are looking at all options and all different scenarios of numbers. So if there were an adjustment, I can't tell you that it won't be a 40% across the board, but that is only one of many, 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 many scenarios.
Right, so regardless of what happens, are we looking at a year, 3 years, 4 years before everything is resolved?
Before it runs out?
No, before it's resolved on what happened.
Before it's resolved. That's a very good question. The time frame for resolution of this, and I'm going to talk about both scenarios, and both scenarios being if the PBGC ends up being something that becomes viable versus the claims issue. If it's the claims, that's litigation. Litigation, it would be unrealistic to say that full-on litigation of these claims would be resolved within a year or two, likely 3 to 4. But that does not contemplate settlement. So obviously there's a potential to settle them well before you get to full-on, full-fledged litigation. So I would say anywhere once we make the claim, there is a part of special counsel's charge and part of the way that I set up the engagement with special counsel is that once we make claims and identify who we're going to potentially pursue, we make an offer to settle in lieu of litigation, which is basically, we believe we've got the ability to sue you. We are going to do so, but before we spend 1 minute putting the words on a piece of paper that are the complaint, let's talk about what our claims will be and what you'd be willing to settle them for. And we make that determination. So that could be anywhere from 6 months after we come to the point where we say, yes, these are the targets and let's pursue them, to 3 to 4 years. I believe if you use for like 38 Studios, for example, that was, I believe, a 3.5 year litigation, about 3.5 to 4 years. I also will tell you this, because I've discussed this with Attorney Wistow, the difference there in terms of the discovery. So we're running into problems with the discovery. His ability to identify who he could pursue in that case was only about 2 to 3 months, but that's because the state had all the documents that need to be reviewed. They didn't have to get a lot from other parties. I'm in the complete opposite situation. I came into this having almost nothing and had to get everything. So that's adding to the time frame. PBGC is a more difficult question. Like I said, I'm in my infancy in terms of my discussions with them, but I can tell you that the federal regulations in PBGC's governing regulations do not provide a time frame for them to make any determination. So I have no guidance with that. I have told them, and they understand the gravity of the situation, but I'm not exactly sure what that means in terms of how quickly they will or will not respond.
Okay, thank you for your time.
Sure.
All of the parties that are involved, is there any type of, since it's been put in receivership, is there any type of liens that you put out here?
I'll repeat her question once it's done.
I thought it was louder than that. Since we're in receivership, are there any type of, or maybe it is already on the table, liens that can be put against the people that are involved at this point, so that if they turn around and try to sell off any of their properties or whatever for profit, is there a lien against them right now so that they can't do that?
The receivership in and of itself does not create any liens. If we felt that there was a party that was acting in a way that was dissipating assets, that was selling off assets that we believe would put us at risk from possible collection, then there are legal remedies we could pursue, such as get a restraining order from them selling it. But we'd have to come to the court with an argument that showed that we were likely to succeed on our claim that that particular asset should not be sold and preserved. We get it for 10 days. Can almost guarantee you that we get it for a 10-day period, but whether we got it beyond that would be a different question. So there is no automatic lien. We would have to go pursue it. But the problem for us right now, not necessarily a problem, but I'm not really concerned about that at this point in time. One, and two, we're not in litigation. So to file a restraining order against a party that you haven't levied a claim against would be premature at this time, because I may find out in a month that I don't even have a viable claim against that party.
Okay, thank you.
Sure.
I just want to clarify something in my mind, because on the Facebook page, they're saying that the church was not obligated to put into our pension plan, but yet the RNs had a contract stating that we had a pension plan.
I will answer. I'm going to give you probably what I hope to be the only lawyerly answer that I can, keeping in mind that I don't represent the diocese and I'm not trying to protect the diocese. From the documents that I have reviewed, the money for the pension, it was an employer-funded pension plan.
Right.
And so the employer in this sense was St. Joe's Hospital. Now, whether or not there's a claim that there was a contractual obligation that arose through the mailings and the pieces of paper that you got, that's a different issue. Whether or not the diocese funded any portion of the money that St. Joe's had, which ultimately might make its way into the plan, that's a different issue. But speaking purely in terms of the language of the responsible party to fund the pension plan, it was the employer, which was St. Joe's Hospital. But that does not mean that the diocese did not have. I'm not standing here, so if the diocese watches this video, I'm not standing here saying that the diocese did not have an obligation. I'm merely saying that from the technical, legal technical language, they were not the diocese was not the employer that was funding this plan. They may have had an indirect obligation. They may have had a direct obligation based on many, many theories. But under a very technical reading, they were not the employer.
Okay. When Charter Care took over, which I'm not sure what year, is that 2008?
The original, well, there was the 09 merger, which was Charter Care, where Roger Williams and St. Joe's and Fatima.
And that's when they had the non-union people go into the different, that they contribute to the...
I believe it was a 401k at that time.
I believe it was a 401k. But they didn't make the RNs go into the 401k. They were supposed to be contributing to our pension plan. It was only new hires.
So the plan was frozen for different groups over different periods of time leading up to that. I think actually the last freeze date, and Marilyn, you might actually be able to help me on this, might be around 2011, I think the last freeze date, or 2010? Okay. So as far as being able to come into the plan, and they were still obligated to fund it. St. Joe's was still obligated to fund it, even though what it basically says, we're not letting anybody else into the plan, so we're closing it off.
Right, they closed it off.
We still have to fund it. So from 09, when that transaction with Charter Care came in, there was still the obligation to fund the plan, even though they had said, we're not letting anybody else in.
Right.
If you're in, you're vested, and that's it. We'll fund it, but everybody else, you have to go to this other option for retirement. That's separate and apart from anything that I'm dealing with. So their obligation to match an employer fund or something like that with the 401k is completely different than their obligation to this plan.
But they weren't putting into our pension plan at that point.
I can tell you that it is without dispute from the records that I've seen that there was a payment made in September of 2008 into the plan of $1.5 million. And then there were no other payments made to the plan until Prospect put the $14 million in 2014. So from September 2008 until June, July of 2014, no, there were no contributions to this plan other than investment income.
Thank you.
Sure. Did you have a question?
I'm just going to add to what she had to say, that in 2014, my husband still worked at the hospital. And here you the kid. Okay. All I was going to say was that I think that was frozen for current employees in 2014. And so that's frozen, but they're contributing to the 401k on their own. That had nothing to do with RNs or anything else.
And 401ks work very, very differently than pension plans.
Exactly.
And,
had nothing to do with the pension that currently we're taking.
Right.
And the other thing I wanted to say was, I just want to thank you for all that you have done for us and how hard you're working.
Thank you. Thank you.